Welcome to That Jewish News Show. I'm Laura E. Adkins, the Forward's opinion editor.
And I'm Benyamin Cohen, our news director.
Don't forget to subscribe to, rate, and review That Jewish News Show wherever you're listening. Your reviews make a world of difference for us and help more folks find our show. And if you're listening or watching on YouTube or Facebook, give a little comment and let us know where you're listening from.
Up on today's show, we are going to be joined by Michael Helfand. He's an expert on religious law and liberty and a frequent columnist to the Forward on all things related to the Supreme Court and the Jews. And he's going to walk us through a blockbuster church-state case currently in front of the Supreme Court that could have an impact on Jews and Jews who don't want to work on the Sabbath, which is super interesting, and I'm looking forward to chatting with him about that.
Yeah, but first we would be remiss if we didn't mention the news of the day. George Santos, the congressman out of Long Island, was indicted on 13 criminal counts for, quote, various alleged fraudulent schemes and brazen misrepresentations.
Brazen.
In other words, he lies a lot. He has a very long documented history of lying about little things and big things. Our colleague broke the news in December that he fabricated Jewish ancestry, including facts about his ancestors' persecution during the Holocaust. And elected officials and local constituents are already calling for his resignation. So we'll be following that closely. But Benjamin, what was your initial reaction to this news?
I mean, anytime I get a news alert about Santos, I kind of have like this eye roll / facepalm emoji that pops in my head. I mean, there's just been so many crazy stories. I actually saw a journalist in New York who's been covering Santos for longer than most people. Has been covering Santos for a couple of years now. Is actually has written a book about Santos, and he was posting on Twitter this morning that you can already pre-order it on Amazon. But I'm guessing he's going to have to rewrite that last chapter.
Yeah, some last minute changes. Also, what a hard book to fact check. I do not envy whoever is in that position. So that'll be interesting. We've already, our colleague Jacob Kornblue, our intrepid political reporter, has been covering this story. We'll put links in the show notes, but definitely more to come on that story. But on a more somber note, and personal note, the Jewish community this week has been reeling from the death of 25-year-old Herschel Siegel, who died by suicide last week. He grew up in an Orthodox community outside of Atlanta, the very same one that Benjamin grew up in, and was a beloved member also of the Yeshiva University community here in New York. And relevant to this conversation, he was also gay. And in the days following his death, many people, including in our pages, pointed out that orthodoxy and traditional interpretations of Jewish law are very stringent and anti-LGBTQ and view homosexuality very strongly negatively. In our pages, one columnist in particular also pointed out that the way that Orthodox communities often treat LGBTQ Jews may have contributed to Herschel's death. And we got a lot of reaction to this piece. We got a lot of people saying it was good and that we need to have a necessary conversation about Orthodox spaces and how LGBTQ Jews fit into them. But we also got a lot of pushback, particularly from some people in the local community. Benjamin, I'm wondering if you can share a little bit of how you're feeling about this whole news cycle.
Yeah, as you said, I am from Atlanta. I spent the first how many years? The first 35, 37 years of my life in Atlanta, and I grew up in this community. I'm friends with the Siegel family. I know them very well, and it was extremely sad news for the community. And yeah, I was actually out of town last week. I was away from work, and so when I came back, I saw some of our coverage of what had happened. And, I think it's important for people to realize when you are the difficulty in working in Jewish news and Jewish journalism is that we're working really, with people we know, with people in the
Yeah.
community, and they're not abstract stories.
Right.
And also, you know, when you see this anytime, there's a tragedy when you have, journalists parachute into somewhere and try to paint a picture of what's going on there. Stories always tend to be more complicated. There's more nuance. And sometimes coverage can be reductionist and miss the specific contours of the story. So I just know, like, some of the initial coverage that we had and some other places had, was highlighting certain aspects of the story. Like you said, we heard from a lot of people, and we've posted some. I think we posted 2 letters to the editor in response to that. So we got actually members of the community writing back. I also want to just say that the Atlanta Jewish community, but in particular the Atlanta Orthodox community, is really unique in that it is largely made up of Baalei Tshuva, which is people who became religious later in life.
Yeah.
And you really see a mix of people at the Orthodox synagogues. People who didn't grow up religious, people who did. You see Black Jews, you see converts. You see it's a real melting pot, and I think it really represents the maxim of Southern hospitality. Everybody is welcome there, and so my hope is that in this coverage, my hope is that we not only shine a light on this important story, but to shine a light on, I think, to let people know that that this is a very special community, and I think,
Yeah, I think there's 2 competing values here, and I think both are really important. And I shared this with a lot of the local folks who wrote in, including a local rabbi. But the job of a journalist is to shine a light on things, and the job of community members is to bring comfort to one another. And those values often align, but they're very often in competition. And it's also difficult because we don't fully know what contributed and how strongly to Herschel's death. There is strong evidence from his public posts that he grappled with his gay identity. There's also very strong evidence from people that knew him and his family that he was loved and accepted by everyone, that and that didn't contribute at all to his place within his specific society. Um, but what is true, and people who've written in that strongly criticized us publishing the op-ed that we did from Mordechai Leibovitz, which I stand behind, they basically said it is true that the Orthodox community, and you and I have both lived in Orthodox communities and know this, it is true that there continues to be a need for a real reckoning with how you square the fact that the Torah itself is very unequivocally, under traditional interpretations of Jewish law, against homosexuality, with the fact that a very significant number of people within the Orthodox community are LGBTQ. And some communities do a better job of this than other communities do. It sounds to me from you and others that the Atlanta Jewish community actually was an example of being able to deal with this.
Yeah. I think separate from this case, to your point, I mean, it's very important to discuss, how the Orthodox community treats the LGBTQ community. We see this right now going on with the Yeshiva University case against their LGBTQ student club. But so that's an important issue to discuss, but we shouldn't necessarily, compound these 2 stories together, because we are not privy to what was going on in, with the Seagulls and with Herschel, and there was a rabbi who wrote to us who said, asking if we would wait till after Shiva, to do some of our coverage, and I think there may be some pros and cons to that, and to think about in the future.
Right. And again, for folks who aren't familiar, Shiva is the week immediately following someone's death, where the immediate family is in the deepest stage of mourning. There are certain rituals that one goes through, and the community often comes and sits with them during this period. Look, it's a really complicated story. We'll post a link both to our coverage and the op-ed, and then some of the letters in response. But the bottom line here is this was a really tragic death of a young person, and it's hard. It's hard to deal with these things. We're going to continue to cover them, and they're going to continue to be hard. So, and we're going to continue to listen to your feedback about how we can do better in covering these difficult things.
Yep. And now it's the point of the episode. We're going to bring on today's guest, Michael Helfand. He's a professor at Pepperdine University and Yale Law School. He's an expert on religious law and religious liberty here in the U.S., and he's a regular contributor to The Forward. Michael, welcome to the show.
So great to be here.
Did I get your bio right? I hope so. Pepperdine and Yale.
Good enough to me. It's fine.
Okay.
Lots of credentials.
Okay, we're having you on.
My mom's going to call you up and say you forgot some stuff, but beyond that, I think you're going to be okay.
What was your bar mitzvah? Yeah, okay.
I was just going to say, yeah.
Oh, dear.
Where are you joining us today from? Are you in?
I'm in Los Angeles, thankfully.
Angeles.
The semester in New Haven is over. I love being there, in case anybody from New Haven is listening, but it's nice to be back with the family and actually remind myself that I have children and what their names are, etc.
I'm sure they appreciate that.
Back home.
We're having you on today to talk about a really interesting case currently in front of the Supreme Court, and I just want to set the stage here for our listeners. It kind of all boils down to must employers accommodate your Shabbat observance? And so the story is there's a U.S. Postal Service employee named Gerald Groff who's Christian, and while his job did not initially require him working on Sundays, when the Postal Service entered an agreement to deliver packages for Amazon on Sundays, he was required to change his work days as well. And he said, this went against his religious convictions. It was his Sabbath. He ultimately resigned from the Postal Service because they would not accommodate him, and then he filed suit. The interesting thing for our listeners is that a bunch of Jewish groups, including the Anti-Defamation League and the Orthodox Union, all wrote briefs to the Supreme Court supporting him. And this really, we like to call it a blockbuster church state case because we're in the Jewish news business. But I think it's going to have a significant impact on Jews and other religious minorities who require accommodation of their religious practices. And I was hoping you could talk about this a little bit.
Yeah, I'm completely with you on the blockbuster piece of it. And, the question is, what's a blockbuster? And I think, Shabbat observance in the United States has for so long been such an integral piece of Jewish advocacy. When you have the beginnings of not just Orthodox Jewish advocacy, but Jewish advocacy generally in the United States, like what was it important for Jews? Like how do they get to be part of American society? One of the biggest sticking points was the Sabbath, a Saturday observance of Shabbat. Yeah, there are Sunday closing laws. There are all these things in place in the 50s and 60s where this advocacy gets started. Shabbat observance became really like a wedge issue. How do Jews make space for themselves in the American story? And to me, that's a blockbuster because in the 70s, we probably didn't get as much from anti-discrimination law as Jews and other religious minorities wanted. And now, kind of 50 years later, we're starting to see maybe a path forward on it.
Yeah, it's interesting to me. Before I worked with you on the couple of pieces you've written so far on this case for us, I was kind of under the impression that there was just a blanket rule that U.S. employers have to accommodate their employees' religious observances, including Shabbat. So I'm curious if you can share for listeners what is really the key question that this case is trying to answer, and aren't U.S. employers already obligated in some way to accommodate?
So we should probably just start with the clarification. Here we're talking about federal law. There are also state laws that protect, what rules govern in the workplace, and some of those actually provide more than federal law does. But, federal law applies everywhere, so it's a big deal. And the answer is, as of this Supreme Court opinion, TWA v. Hardison in 1977, the answer is employers don't have to go very far. One way to frame the question is, and I've tried to do that in some of the pieces, how far must employers go? Accommodating somebody often requires logistical challenges. Sometimes it chafes a little bit with respect to what you're trying to do in the workplace. Sometimes it just costs a bunch of money in order to accommodate. And so what you're trying to ask is not whether yes or no, but what you're really trying to ask is how far must you go? And, the 1964 Civil Rights Act, Title VII of the 1964 Civil Rights Act, tells employers that they have to accommodate. They have to provide religious accommodations. And it says that they have to do so until, this is the how far question, it imposes an undue hardship. Law is rough because it uses words. It's like, oh, we can solve this problem with a couple of words. We told you undue hardship. Now you know what to do. And the answer, of course, is, well, nobody knows what to do. What does that mean? How far do you have to go? And in 1977, the Supreme Court said not so far. It means that you have to accommodate unless it causes or imposes a de minimis burden. I know. Why did they use de minimis? Why didn't they just use English? Okay, but
because
they
it's
said
a fancy word.
Yeah, fancy words. And then I always have to have that a positive. When I write the piece for you, I have to write like, what does de minimis mean? Like a very little bit. A de minimis burden on the employer. So if there's a little bit of burden, the employer gets to say, this is too much. I'm not going to accommodate you. And you can imagine that's not a very demanding standard. And as a result, this is something that has really many religious minorities have butted up against in litigation, trying to make their way in the workplace. And at times, it's as a result also forced employees who are members of religious minorities whose practices just don't conform to what the majority is doing. And that's why they need accommodation. So they don't conform to what the majority is doing. And at times, it's made them choose between, getting a paycheck and observing their faith.
I think, this is obviously a Christian case dealing with work on Sundays. And when we hear the phrase church state issue, we think, oh, it doesn't relate to us. It's a church state issue. But can you talk about, this is an inherently Jewish issue. And what will this decision mean for American Jews?
Oh, yeah. It's, Jews in many ways have been over the years, over the decades, Jews and Seventh-day Adventists have really pushed this issue, I would say, the most. And that's probably not surprising when you think about it. Sabbath has been the biggest issue here. And how far must an employer go? Sometimes people try to paint these cases as, well, you're going to provide for the religious employee, and who's going to shoulder the burden? It's going to be other people in the workplace. And that's not fair. And there's some really important thinking on that front, and it's a fair point that you need to work through. But most of the time we're talking about cases where an employer can solve this problem with money, just paying somebody overtime. That's just the reality in almost all these cases, whether it was TWA v. Hardison in 77 or whether we're talking about now Groff v. DeJoy in 2023. And so really what Jews are looking for and why they press this and why all these Jewish institutions who normally fight about so many church-state issues, why uniformly they've come out in favor of this postal worker, is ultimately because, there's the financial piece of this. I want to be able to earn a paycheck. That's what makes my life workable, that what I can provide for my family. But there's also kind of this kind of dignitary piece to the case. The idea that I don't do what everybody else does, this very prototypical American story, my life, my rhythms, my holidays, all of this stuff is different than what, let's say, Christian America does. And the standard that we're going to use to figure out how much space needs to be provided in the workplace is almost a metaphor in that way. It's really asking the question of, the institutions of American life, how far do they have to go to really make room for people who don't look like the norm? And this is the American Jewish story. It's always been the American Jewish story. The desire to have equal footing, to have equal rights, to have equal access. So much of it has been about, having our story reflected in the American story. And so it's not surprising that this has garnered so much interest. And in many ways, a Jewish community that can rarely speak in one voice, and maybe for very good reason. But on this issue, on this core issue, everyone looks at this standard and says, the law can't be this stingy.
Right.
Yeah, I was kind of surprised to see, on the one side we had all the Jewish groups for the most part supporting the plaintiff in this case, but I was very surprised to see the largest federation of unions, AFLCIO, actually filed an amicus brief in favor of the post office. And when I think of that story of the history of Jews getting acceptance for diverse practices in the workplace and also just rights of workers in general, I think of the big, often Jewish led labor organizing movement as well. So it seems odd to me that an organization about workers' rights is siding with the employer here, but am I wrong? What's your read of this position?
Yeah, so this is actually a very essential piece of all these cases. Um, and what you often have in these cases is you have the employer and then you have a union. And the union has negotiated who gets off on Saturday, who gets off on Sunday, who wants to work on the weekend. I don't want to work on the weekend. I want to watch football on Sunday. That's my
Right.
pastime. So everybody wants off. How do you decide? And so what the union does is typically based on seniority. Some people get to pick their shifts, and some people have to wait in line to pick their shift. Now, here's the problem. The problem is if somebody gets to go to the front of the line because they have a religious claim, it upsets the manner in which a union can represent its members. And that's a big deal. But this is why I emphasize that other point that I made before. It's very possible, maybe even likely, that if these cases ended up at bottom, at their core, being about union employees doing battle with religious employees, you would have like some really interesting, I would think, moral and ethical questions here about, how to give priority and precedence. What does it mean to negotiate? There's a democratic impulse here behind the unions. They're trying to represent the collective will of the employees. But the truth of it is almost invariably, and you can probably imagine this, if you pay enough money in order to give somebody overtime, especially these Sabbath shifts, you can typically solve the problem. This is kind of the dirty underbelly of a lot of these cases where, some people and some advocates want to make this, at least in my view, about this clash of like religious versus non-religious. But ultimately, what these cases, when you press really hard on them, they're about the employer trying to save a little bit of money in order to, well, they'll accommodate the union, but they prefer not to have a demanding standard on the religious side of the ledger.
So it seems like on the one hand we have this competing hierarchy of values, which we have in all sorts of cases. Is religious liberty primary, or is this like democratic organizing principle taking precedence? But there also seems to be just a really fundamental question of like what does it mean to be accommodating. It's crazy to me also the last significant case on this was in the 70s. Like that's a really long time ago. I mean, have there been other recent things that you're looking to for hints on how the court might determine or change this standard of what undue burden is?
Yes, let's think about how this might work. What might the words, how's it going to reinterpret undue hardship? So there are a lot of, good data points out there. People, by the way, have been pressing for this case for many, many years. There have been a lot of attempts to get this kind of case before the Supreme Court. I think I wrote an article for the Wall Street Journal. Am I allowed to say that here?
Yes, it's fine.
Yeah.
Read that out.
We
Sorry
love
about
all
that.
publications.
Okay, I just wanted to make sure that I feel if I'm talking to you, it means like, and I wrote for somebody else. Was I cheating? I hope that's okay. Um,
All good.
and about a different case where I think folks thought maybe the Supreme Court would take one of these Sabbath cases, and they haven't. They just haven't, and people are puzzled as to why they picked this one. There's some things better about it, some things worse about it. Um, but through those cases, let's think about it. How does the Supreme Court take a case? You need 4 votes. So if there are 4 votes to take the case, it probably means there are at least 4 people who want to do something with this case. So that's kind of where you start. If you're trying to predict what's going on, you have 4 votes and 4 people. You need 5 to win, but 4 votes who clearly want this case as a vehicle to do something. And most people assume that means change the way in which the law works at present. Now, how far are they going to go? this is hard to figure out. I think a lot of people thought, well, if they're taking the case, they want to shake things up a little bit. They want to say, it's really hard to understand the words undue hardship to mean you have to do a little bit, but not much more. I mean, it's just a weird reading of English. And in fact, the words undue hardship, when it comes to the Americans with Disabilities Act, means something very different. It means you have to significant expense and cost. But it's in this legislation and Title VII, religious accommodation, that it's a much stingier standard. So people assume, well, it's weird. The old case is a little bit weird. 4 justices said they want to take it. Surely something's going to happen. But if you're trying to predict their, oral argument gave us a really great window into this. And there's some indications that the Supreme Court may not go as far as a lot of people thought originally. And here's the big thing. Take the Dobbs, right? The Supreme Court's abortion opinion, okay? Because why not? Let's just up the ante and introduce other.
Our listenership just doubled, yeah.
There it is. Okay, good. Send the word out. Tweet it. They're interpreting the 14th Amendment, okay? And when the Supreme Court interprets the Constitution, so it's reluctant to overturn past decisions, but it'll do so. It has standards for under which to do so. When it comes to interpreting a statute, not a constitutional provision, the Supreme Court is even more reluctant. And let's think about why. You can't tell the people who wrote the Constitution, hey, can you fix it up a little bit? Yeah, here's what we think it means now, but if you don't like that, kind of fix it. I mean, they're all dead. So that's not going to work. But when you're interpreting legislation, Congress, if it doesn't like how you've interpreted the words, can just take out a pen. And they can say, we saw what you did, don't love it, we're going to fix it. And when Congress doesn't do that, the Supreme Court, pauses a little bit. Well, wait a minute, why didn't they do that? Maybe they agree with what we've done. Like, should we really overturn that? Or maybe your complaint is better posed to the legislature. And so there's a real reluctance when you're coming to legislation in order to overturn a prior decision. And that came through loud and clear in oral argument. And so it left the court, court watchers like myself, with a real puzzle. On the one hand, the Supreme Court seems to want to not overturn its prior decision. Keep the standard, how far employers have to go, super stingy. I like the word stingy. It's because I don't like the old standard.
Right.
Super low. But at the same, they like the old decision, but they want to keep the old decision, but kind of move the standard a little bit. It's like this funny little dance. We're not overturning anything, but there are some things like this. Justice Kavanaugh, during an oral argument, he's like, wait a minute, if you look in footnote 14, literally footnote 14, and you read it in a particular way, can't we get a little something more out of the old standard? We don't have to discard it. Let's just tinker with it a little bit and fix things up. But, nothing to see here. We're not overturning. We would never do that. We're just changing without changing. And I think that's where people are starting to wonder, well, if you're going to keep the old stuff on the books, but you're going to try to change, how far can you actually go? And I think that's the big question in this case. The court's going to do something. They're probably going to tinker with the standard. But if they don't overturn old decisions, how much higher can they actually get the standard to be?
Right. We all think of this, in the Jewish community, we think of this as probably a positive thing, if there is more accommodations for Shabbat observance. And I'm curious your thoughts on if there would be negative impacts. Like, does this open a Pandora's box that could actually hurt American Jews, where they take this unfettered right to religious accommodations, to the extreme. And, for example, if people don't agree with, abortion, and does that mean if a police officer is asked to guard an abortion clinic, can he say, that goes against my religion, I'm not going to guard an abortion clinic? What are your thoughts about that?
Yeah, I mean, the kind of parade of horribles, I don't know, let's throw some others on the table. Vaccine mandates, that's obviously been in the news. People saying, listen, my religion says I don't have to get vaccinated for a whole host. I'm prohibited. I can't. For getting vaccinated for a whole host of, whatever it may be. And so I know we have a rule in the office, but I'm not listening. Any standard that if you gave it, unfettered right to ravage the employment system, I think you're going to have problems. But keep in mind, the standard baked into it, there always was a limit, right? That's what undue hardship means, that there's some line, some standard where if you go too far, well, then the employer gets to say, no, 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 no. Now we've gone too far. And again, the question we started with is, it's not yes or no, right? It's how far must an employer go? And so one would hope, again, you move a standard, it injects some legal uncertainty, no question. But there should be a way to move a standard that goes beyond, I don't know, one of the examples is under the current standard, if it impacts workplace morale, then you don't have to accommodate. And that feels like, oh, come on. That can't be right. I mean, you've got to be able to do better than that. And to move it up, but not hit like, well, you don't have to guard an abortion clinic. Like, there's got to be a line in between those two. And you'd like to think the standard of undue hardship does a decent job of capturing that if we can just draw a line that thinks a little bit more about how to incorporate and accommodate people in the workplace and not say, we'd like to open up the floodgates to everything. I think the law was written originally in a way that can make that happen. And I think it's really about just being a little bit more, finding a little bit more space when it comes to the institutions of American life.
Right.
That totally makes sense. Michael, this has been super interesting and I think helpful. What is your prediction for what is going to come out of this? And also, when might we expect a ruling on this case?
I'm guessing June. So like a couple days in advance, Laura expects an email from me. I'm thinking of writing a little explainer. I want to say something to you. I hope I'm injecting this because Laura, we've never hung out before, so I finally get to say this. When I get to write for the forward, so I feel like it's a form of protest. I want to explain what I mean. This should be fun, or you can cut it out later. Here's what it is. There is so much of the conversation around law now is that it is politics all the way down, that there is nothing coherent going on. And my opportunity to explain law is my way of saying that it is not politics all the way down. I never write that at the beginning of the end, but I think that's important. And so when we think about the way in which law might constrain the Supreme Court on this issue, I think it's important. What we're ultimately saying is like, we don't believe it's politics all the way down, and that the court is genuinely struggling with the puzzle I just described, which is, on the one hand, maybe Congress should have acted, so should we really be overturning past decisions? On the other hand, oh gosh, reading undue hardship to mean basically nothing, that seems super bizarre and weird. So how do we navigate these legal considerations? And I think that's what the court is struggling with. And here's my best guess. My best guess is, there are a lot of religious accommodations issues that have nothing to do with the Sabbath. Think about hijabs in the workplace. That was a Supreme Court case a couple of years ago. There are lots of things. Abercrombie and Fitch didn't want somebody wearing a hijab because, you have to look like Abercrombie and Fitch. Okay, that's not going to work, guys. That can't be a thing. But you can see how there are other areas, have nothing to do with the Sabbath and shift swaps, etc., that don't really impact the union. And I think whatever we get in this case, I think it will do a lot of work in those cases. I think in those cases we'll get a standard that once you implement it, people will say, oh, things like dress and food access, maybe all these kinds of things that are important. The Sabbath stuff is going to be tough. The Solicitor General, arguing on behalf of the Postal Service, was pretty firm on this, like requiring more money on an ongoing basis, whatever the standards should be. It shouldn't require employers to do that. And I have a sneaking, there's a chance the Postal Service might win on this point. I sure hope it's not true. I really, really hope that ultimately the Supreme Court finds a way, even if it wants to keep its precedent, to say, Amazon, a couple bucks per hour once a week, that's something that you have to do to make space in the workplace. I think that's the pressure point. And I'm nervous that the court won't go far enough, but I think we'll see in June.
Yeah.
Michael, thank you so much. This has been really illuminating, and we'll put links to your two wonderful articles so far. Good to know we'll be expecting a third once we have a ruling. But thank you for joining us.
Pleasure hanging out.
Such an interesting. First of all, he's such an interesting guy, but that's such an interesting conversation. More and more we're seeing these cases at the Supreme Court that impact, I think, all religions in America. Last year we had the case with the high school football coach who wanted to pray with his team.
Kennedy.
Yeah.
Yeah. Lots
So
of ways these cases affect us. But
s-
now
it's
for
rare.
our
It's rare you're going to see like a Supreme Court case that has to do with like keeping kosher or something like super niche specific for the Jewish community. But it's interesting to see how these other larger church state issues can impact American Jews.
right, this one definitely has a close parallel. So,
Yeah.
shall we end with our recommendations of the week?
Yes, I think we shall. Do you want to go first?
Sure. Mine is a more exciting one for people that live in New York, but there are hybrid options to experience it. I have long been fascinated with the fact that the brand Chanel, which was literally started by a Nazi spy, Coco Chanel, um, has turned into a brand beloved by Orthodox Jews with money and proclivities toward designer clothing. For those who are not familiar, it's a astronomically expensive designer clothing brand, even on resale sites. I check all the time. But the Metropolitan Museum of Art in New York City every year does a costume exhibit as a fundraiser. You've probably heard of the Met Gala. You see all these celebrities in crazy outfits. And they do so in collaboration with Vogue magazine. And this year, the gala honored Karl Lagerfeld, who passed away recently. He was not Jewish, but we ran a piece I actually commissioned while I was still at JTA. But there's this very interesting narrative of how Karl Lagerfeld and his personality helped transform the reputation of Chanel from this Nazi brand into one that is now pretty beloved by celebrities and Jews. So, my recommendation from the week is the exhibit at the Met is open now until July 16th. They have pretty much an overview of Karl Lagerfeld's outfits, and even like they took his desk and kind of transported it. My mom was very sad, since she lives in Missouri, that she couldn't experience it, and was happy to see that the Met has an online view of most of the pieces in the collection. There was also a really nice spread in Vogue. We'll post links to all of that. But if you're in New York City, get a ticket to the Met for free and go check it out. Benjamin, I assume you're going to have a more highfalutin recommendation than mine. But
than high fashion.
yeah.
My recommendation for the week, I discovered probably in the last week this Hasidic music duo called Zusha. I hope I'm pronouncing that right. Zusha.
Yeah.
Everyone in my social media feed is posting about them. Apparently, I guess I'm last to the scene here. I don't know how else to describe it, but it's like Hasidic electronic dance music.
What's
And
interesting is they actually started at NYU while I was there.
Oh, wow.
And they were like fixtures of the Chabad. There was actually one year that they performed a concert on my roof on the Upper West Side. So I'm happy you're discovering them. They're an exciting duo now.
Yeah, like I said, I'm late to the party. But if you follow them on Instagram, what's funny is they post these videos, and it looks like they're just like sitting in one of their living rooms, and one of them is like holding his baby on his knee, and rocking his baby on his knee, and he's singing, and the friend next to him is using like all these household items instead of instruments, like they're like knocking on a box of tissues or shaking a baby rattle. So that's pretty cool. But what I want to recommend is they dropped a new song overnight. It's called World to Come. You can listen on Spotify. I've guilty pleasure. I've had it on repeat all day. And you could follow them on Instagram, Zusha Music. That's Zusha Music on Instagram, and we'll put a link in the show notes.
Yeah, amazing. I'll have to check that out. I haven't seen their latest. But
yeah.
Thanks for joining us this week, folks.
All right. We'll see everybody next week.